What I'm most interested to watch in the legislation space is the new anti-discrimination legislation and the way that that will play out. It's been reasonably controversial in the press in recent times with claims that it's going to limit freedom of speech. From my perspective, what's more important is that it involves a shifting onus, the result of which is that if a claim is made against an employer and some evidence is put behind that claim, the onus shifts to the employer to demonstrate that the conduct complained of was not discriminatory, and that's going to be a difficulty for the employers. Adverse action is growing as an area. Discrimination law is likely to follow suit, and we're seeing an increasing use of those laws by senior employees as well as more junior employees. So it's providing a cost-effective way for individuals to litigate in respect of issues that they're not happy with in employment, and that's the space that I'm seeing really grow at the moment.
Well, let's start by talking about the rise of adverse action complaints, because that's probably the most significant thing that most employers are facing at the moment. Massive increase in the number of adverse action complaints that have been brought. Frequently they are brought as something of a collateral attack upon a performance management process or a dismissal. Sometimes those claims are brought in the blaze of publicity and with claims for multi-millions of dollars in damages.
What we're seeing is a wider range of individuals likely to pursue them, and when they pursue them, the process gives easy access for those people to a jurisdiction, in the first instance the Fair Work Commission, and from there the federal court. Damages are uncapped, and so the outcome for an unsuccessful respondent, such as an employer who can't demonstrate that it did the right thing, can be a substantial damages award against them.
Well, I think that there are two big things that could happen in relation to adverse action claims. The first thing, obviously, is the election. And if there is a change of government and there's a change in control of the Senate, then you could well see changes to the adverse action laws. In fact, I think it would probably be quite likely. The second thing is there is developing case law in the area. There's going to be at least one decision which is very interesting in relation to not only adverse action complaints, but the bringing of proceedings with associated publicity.
One way in which employer systems fall down and cause cost to be suffered by the business is in the area of fraud prevention, fraud detection. And we've seen numerous examples, most recently Sims, where fraud has been able to occur apparently unnoticed for an extended period, with the cost to the business measured in millions of dollars. So proper processes for ensuring that opportunities for fraudulent activity are minimised, and ensuring that opportunities to detect fraud are identified as early as possible is critical in addressing that potential loss, and every business is at risk of it. All businesses have money flows in and money flows out, and the human mind is a wonderful thing. It can always think of a way of trying to override the systems in order to achieve an outcome that wasn't intended.
The next thing, obviously, that everybody will be focusing on in 2013 is the election. Really, the big unknown is the coalition's policy on industrial relations. Now, obviously, the burning question is, would the coalition reintroduce AWAs? And there's also the possibility of something that is approaching an AWA but is not an AWA in name.
We currently have very complicated laws in the Corporations Act that cap the amount of remuneration or benefits that can be paid to individuals at a certain level in a company on termination. Those laws are going to get more complicated, and disclosure laws in relation to executive remuneration generally are going to become more onerous and more complicated to comply with. So what's critical at this time is to track the legislative changes that are currently in place, and when you get to the point of reporting to your annual report or dealing with a senior executive termination where there are issues about whether the payment amount will reach the cap, you need some really clear and decisive advice, and it's not straightforward. There are lots of traps in there.
Now, there's been a steady rise of bullying complaints and a steady rise of interest by regulators in claims of bullying in the last few years, particularly the safety regulators, so Safe Work Australia and others, basically releasing codes of practice that try and define what bullying is. And they'll also investigate incidents of bullying as a potential breach of workplace health and safety laws.
What's always been important and is more important now than it's ever been is ensuring that you've got processes in place to demonstrate that the reasons you took a certain decision, whether it was a decision not to promote, a decision to terminate, a decision to prefer one employee over another, was taken for good, legitimate business reasons rather than for reasons that an employee can legitimately complain about. So that continues.
Well, I think it's a very good opportunity to hear a number of experts in the area into one place talking about topical issues that could affect you in 2013. We have to be aware that practicing in HR and IR is a constantly changing and evolving area. I think that most practitioners in the area would acknowledge that there have been significant changes in only the last 12 months or so in terms of practice and what we're seeing. It's very important as a practitioner to remain on top of that. Of course, the issue is if you don't remain on top of it, it may be that you're caught by surprise when you get the next adverse action claim and it winds up being you who's on the front page of the paper or your organisation anyway.
Employment law in Australia is an area of constant change, whether it's legislative, whether it's case developments, or whether it's just practice developments. Conferences like Tonkin's annual Employment Law Conference are a great way of keeping on top of what's going on in this space.